viewers. Hello everyone. In this video, I will discuss the comparison between international conventions and national law in the maritime industry. International conventions provide global maritime standards, while national law gives those standards legal effect and enforcement within a country. Before making the comparison, it is important to understand the role of the UN, IMO, ILO, and Malaysia's MSO 1952 in applying these maritime rules. The United Nations, or UN, was established in 1945 after World War II to maintain international peace and promote global cooperation. In the maritime industry, the UN supports international shipping by promoting maritime safety, environmental protection, and fair working conditions for seafarers. Today, the UN has 193 member states that work together to discuss global issues and develop international policies. One of its important priorities is achieving the Sustainable Development Goals, or SDGs, by 2030. In the maritime sector, this includes reducing marine pollution, improving ship safety, and ensuring proper labor standards for seafarers. The United Nations consists of 6 principal organs that help maintain international peace, cooperation, and international law. The General Assembly serves as the main discussion body of the UN and adopts resolutions related to maritime security, environmental protection, and shipping practices. The Security Council focuses on maintaining international peace and security by addressing issues such as piracy, maritime conflicts, and the protection of important trade routes. Meanwhile, the International Court of Justice resolves disputes between countries, including cases involving maritime boundaries and shipping rights. The Secretariat supports the daily operations and implementation of UN policies related to maritime affairs and sustainability. The Economic and Social Council, ECOSOC, plays an important role by coordinating the activities of specialized agencies, such as the International Maritime Organization, IMO, and the International Labor Organization, ILO. The IMO is responsible for regulating international shipping and establishing standards for ship safety, pollution prevention, marine environmental protection, and ship certification. At the same time, the ILO focuses on protecting seafarers' rights and improving working conditions through conventions such as the Maritime Labor Convention, MLC. Lastly, although the Trusteeship Council is no longer active, it historically supervised trust territories moving towards self-government. The International Maritime Organization, IMO, is a specialized agency under the United Nations responsible for regulating international shipping. It was established in 1948 in Geneva as the Intergovernmental Maritime Consultative Organization, IMCO, and officially changed its name to IMO in 1982. Headquartered in London, United Kingdom, the IMO currently consists of 176 member states. According to the IMO GICIS Treaty List, 69 international maritime conventions and related instruments are listed. Among the major conventions developed by the IMO are the SOLAS Convention, which establishes minimum safety standards for ship construction, equipment, and operation, the ISPS Code, which strengthens ship and port security, and the MARPOL Convention, which aims to prevent marine pollution caused by ships through the control of oil, chemicals, sewage, and air emissions. The STCW Convention 1978 sets qualification standards for masters, officers, and watchkeeping personnel, ensuring the competency of seafarers worldwide. The Coal Regs 1972 Convention establishes navigation rules to prevent collisions at sea, particularly in congested shipping routes. These conventions play an important role in improving maritime safety and supporting sustainable development in the global shipping industry. The International Labor Organization, ILO, was established in 1919 under the Treaty of Versailles and is one of the oldest specialized agencies of the United Nations. The ILO focuses on promoting labor rights, social justice, fair working conditions, and human rights worldwide. A unique feature of the ILO is its tripartite structure, which involves governments, employers, and workers from its 187 member states in developing international labor standards through cooperation and social dialogue. In the maritime industry, the ILO plays an important role in protecting seafarers' rights and improving their working and living conditions. One of its major contributions is the Maritime Labor Convention, MLC, 2006, also known as the Seafarers' Bill of Rights, which sets minimum international standards for wages, working hours, medical care, accommodation, and workplace safety on board ships. Together with the SOLAS Convention, MARPOL Convention, and STCW conventions, the MLC 2006 is recognized as the fourth pillar of international maritime regulation because it complements technical ship safety requirements with protection of the human element at sea. The ILO also introduced other important instruments such as Convention 192, Protocol 5, and Recommendation 209 to strengthen social protection and employment standards for maritime workers. Malaysia has also shown commitment to maritime labor standards by ratifying 19 ILO conventions and 1 protocol. To ensure effective maritime governance, the ILO works closely with the International Maritime Organization, IMO, by combining labor rights with technical and safety standards. This cooperation helps protect both the welfare and safety of seafarers in the global shipping industry. An important feature of the Maritime Labor Convention 2006 requires ships of 500 gross tonnage and above engaged in international voyages to carry the Maritime Labor Certificate and Declaration of Maritime Labor Compliance, DMLC. These documents prove compliance with international maritime labor standards and may be inspected by both flag state authorities and port state control officers. Malaysia has ratified 31 international maritime conventions, consisting of 30 IMO conventions and 1 ILO convention, which is the Maritime Labor Convention, MLC 2006. These international conventions consist of several important components. Articles outline the responsibilities of member countries, while definitions ensure a consistent understanding of key terms. Recommendations and guidelines provide practical advice for implementation, whereas rules and codes establish mandatory operational and technical standards. Resolutions are adopted by international bodies such as the IMO to support the implementation, interpretation, and updating of maritime conventions. Protocols and amendments are introduced to update conventions according to technological developments, environmental concerns, and new maritime challenges. Among the key conventions ratified by Malaysia are SOLAS for safety at sea, MARPOL for pollution prevention, STCW for seafarer training and certification, and MLC 2006 for seafarers' rights and working conditions. By ratifying these conventions, Malaysia aligns its maritime practices with international standards and strengthens its role as a responsible flag state. However, ratification alone is not enough. To make these international standards enforceable in Malaysia, they must be implemented through national law. Malaysia implements international maritime conventions through the Merchant Shipping Ordinance, MSO, 1952, together with subsidiary legislation, ministerial regulations, and Malaysia shipping notices issued by the Malaysia Marine Department. Under Section 518 of the MSO 1952, the minister has the authority to make maritime regulations that carry legal force once published in the Gazette and approved by Parliament. Section 519 allows the minister to revise maritime-related statutory fees when necessary, while Section 590A empowers the Director of Marine to issue Malaysia shipping notices. These notices provide specific guidance and requirements on matters such as navigation safety, maritime security, pollution prevention, and ship certification. While Section 81 requires ship owners and operators to keep updated maritime laws, MSNs, and international regulations on board, failure to comply may result in penalties of up to Rm 25,000 per vessel. Through this legal framework, Malaysia transforms international maritime conventions into enforceable domestic law. Malaysia's maritime law is mainly governed by the Merchant Shipping Ordinance, MSO, 1952, which acts as the parent law for the maritime industry. It has provided the main legal framework for matters such as ship registration, licensing, maritime regulation, certification of ship personnel, port control, vessel navigation, and maritime enforcement. The ordinance has also been updated over time, including through Act A1551 in 2017 to improve areas related to ship registration, ship owner responsibilities, crew management, and other maritime matters. However, the MSO 1952 mainly outlines the general principles and objectives of maritime regulation. To provide more detailed technical and operational requirements, the Minister and the Director of Marine are empowered under the MSO to create and implement subsidiary laws and bylaws. These subsidiary laws help ensure the effective implementation and enforcement of Malaysia's maritime laws and international maritime standards.